It is your constitutional right to have a fast and speedy trial. Hello, good morning, good afternoon, good evening, whatever time zone you are in. My name is Attorney Justin Camper. I am a criminal defense attorney located in Northwest Indiana. And today, I want to talk to you about, should you get a speedy trial if you are a criminal defendant? So let's talk about it. So let's talk about what is a speedy trial. A speedy trial is basically where you force the state to try you within a certain time frame. It is your constitutional right to have a fast and speedy trial, and especially if you are incarcerated due to your charges. So in the state of Indiana, the state has to try you within 70 calendar days. 70 calendar days if you are a criminal defendant who requests a speedy trial. You have to request it in writing. It has to be a note that you are requesting a speedy trial under Indiana Criminal Rule 4, and you have to make that note to the judge. And the judge, the court, and state has to work together to try to get you a trial within 70 days. And there is exceptions. The number one exception is if you continue the case. So if you are asking the judge as a defendant through your attorney for a continuance, then the 70-day rule doesn't apply. Another continuance that the court can use is if there's court congestion, meaning there's just so many cases it's impossible for them to try you within 70 days. But then the court, where the prosecuting attorney has to file that, as soon as possible, and let us know that they can't do it within 70 days. The court has to make note of this, and they have to try to get you within that 70-day time frame as soon as possible. Now, what happens if you can't get trial within 70 days? And they have no exceptions. Then if you can't get trial within 70 days, then the court will be forced to release you from jail. And you can be released from jail. Now your charges may not get dismissed, but your defense attorney could ask for charges to be dismissed, and the judge could grant it. So if you are able to get released because of this rule, that's definitely a plus for you. Now another rule is that if you once you're released, if you got released because the speedy trial rule was violated, or just in general, you request a trial, the state is supposed to try you within 6 months in the state of Indiana. Now, check your local jurisdiction. But the state of Indiana, as of now, as of 2023, you have to be tried within 6 months. So what that means is that the state can't try you within 6 months. If you requested a trial and you've been released from from jail, then you can ask for your case to be dismissed. So there are benefits, and there are pros and cons, benefits and negatives to everything. And that's why you want to talk with your criminal defense attorney, whoever you hire, if you have charges, to make sure you figure out what's best for you. Here are some benefits to doing a fast and speedy trial. Obviously, if the case against you is very weak, you can force the state to try to prove it within that time frame. For some reason, you can't afford bond. You're going to be stuck in jail until these charges are done. There might be other reasons where you just really want to get a fast and speedy trial. But also, there are reasons why you may not want to. So typically, defendants ask for continuances because the defense attorney wants to do a proper, thorough investigation of the charges so that they can gather as much evidence to prove your innocence. So with that being said, you may not want to do a fast and speedy trial. So you want to make sure that you can take your time with it, because you want to give the state enough time to see the case from your side and maybe able to resolve it without having a trial. So it's important to kind of look through that and kind of figure out, should you or should you not ask for a fast and speedy trial. Now, I'm hopeful that this was helpful for you, and that the information that was given can be used for you and your attorney. I do advise that you need to contact an attorney if you don't have one. But if you are located in Northwest Indiana or Northern Indiana, and you have a criminal matter and you would like to speak with me about it, feel free to give me a call at 219-281-6166. that I can set up a free 15-minute consultation for you. We can talk about your case. So just to recap really quick, today's video was about should you do a speedy trial? The answer to that is it depends based off of your strategy that you come up with your attorney. And there are benefits and there are pros and there are cons in the situation. So feel free to give me a call. I'd love to talk to you. If you think you may need to do a speedy trial, if you have a loved one who you think may need to do a speedy trial, feel free to give me a call. You are located in Indiana. So thanks so much for listening, and I hope that you have a super productive day and a blessed day. Thanks. Bye. Thank you for watching this video. I'm so glad that you are here. I just want to put out a disclaimer that even though I'm a licensed attorney, you should always consult with an attorney in your specific jurisdiction before you take on this legal advice. This is more so like legal information and general legal advice that you can use, but you should always follow up with your own attorney in your local area, or give me a call that I can give you personalized legal advice. Otherwise, I hope you enjoyed this information. Please like and subscribe so you can get more information. And always remember that I would love to hear back from you. So please put your feedback in the comments. And if you have any other legal topics that you would like for me to discuss for your business, please make sure that you put it in the comments. And remember, stay legal. Thanks. For your favorite attorney, Justin Kemp.